So there you have it, Matthew, a client who is going to insist upon doing that. What would you do now if he's going to do it and you don't want him to do it, but in preparation for his going on?
Well, sometimes it's the court's determination, and the court can direct you to assist in his preparation. But if you have a client, for example, who's about to perjure himself, you know he told you in the office, I did it intentionally, and now all of a sudden he's going to take the stand, you cannot suborn perjury, and you have another problem, and sometimes you need judicial intervention with that. And that is vis-a-vis the other problem you have, which is you're, according to the canons of ethics, you're to zealously represent your client to the best of your ability, but you cannot suborn perjury. So it depends on why you don't want him to take the stand. In any event, as the navigator of the ship, as the person who's the lawyer on the case, you do everything you can. If you think that this guy is going to sink his ship, you think his ship might be going down anyway, but he's just going to make it worse, you have to do everything you can to try to avoid that from happening, because he could possibly, he could perjure himself. He could be facing other charges in addition to the ones he's on trial for.
Well, in this case, we have, as we said earlier, the videotape confession that's already out there. Culpability is not at issue. But let's go now into the courtroom where, as we heard Mr. Sheehan, it was not his idea and it was against his advice, but his client did decide to take the stand as we go in for the direct examination of the defendant, Raymond Childs.